members, for the stakeholders here present, and I use that world-renowned Professor Idonije, SAN, as a point of contact. Very distinguished ladies and gentlemen, I want to say that I am greatly appreciative to the Senate Committee on Judiciary, Human Rights, and Legal Matters for the opportunity to provide my views regarding the proposed amendment to the Terrorism Prevention and Prohibition Act. While the Ministry shares the National Assembly's resolve to eliminate the existential threat of terrorism, I wish to inform that the critical review of the proposed terrorism bill has raised certain concerns, particularly relating to the inclusion of death penalty as a prescribed sentence for convicted terrorists. Our position is informed by a rigorous assessment of the legal, strategic, and human rights considerations and discussion across or offshore in diaspora, which are outlined below for the committee's kind consideration. It is undoubted that the bill proposes to address the legislature's deep concern over the escalating security challenges facing our dear nation. However, I believe we must be cautious not to adopt a policy that, while emotionally satisfying, may prove counterproductive to our ultimate goal of a safer Nigeria. From a critical perspective, a tactical perspective, it is our view that the proposal to include the death penalty for convicted terrorists should be viewed because it inadvertently facilitates the martyrdom trap. It is critical to note that the fight against terrorism deals with an enemy often driven by radical ideologies, where a state-sanctioned execution is viewed not as a deterrent, but as a validation of their cause. We must avoid giving these groups the matters they need to fuel their recruitment drives and incite further retaliatory violence against the state and its citizens. Furthermore, we must consider the protocol bottleneck that the inclusion of death penalty creates for international cooperation and mutual legal assistance. As the committee may be aware, many of our international partners in the global war on terror will not extradite high-profile suspects if they face the risk of capital punishment. By including this provision, we may inadvertently create a safe haven abroad for the very masterminds we seek to bring to justice, as foreign courts will block their repatriation to Nigeria on human rights grounds. Beyond these ideological concerns, it is critical to confront the harsh administrative reality that has historically undermined capital punishment in Nigeria. As you are aware, there is a long-standing and pervasive reluctance, except during the military era, among the state governors to sign execution warrants, often due to moral, religious, or political considerations. This hesitation has created a de facto moratorium that leaves condemned terrorists sitting indefinitely in our correctional facilities. The state of legal limbo not only serves as a conscious psychological drain on our justice system, but directly contributes to the chronic overcrowding of our prisons. By keeping these high-risk individuals in the general prison population for decades, we inadvertently create radicalization hubs where convicted terrorists can influence other inmates, posing an ever greater long-term security risk to the Federation. In addition, the risk of judicial error remains a reality in any legal system. The finality of death penalty leaves no room for the rectification of errors should fresh evidence come to light. To maintain the moral authority of the Nigerian state, we must ensure that our punishments are both firm and reversible in the face of new facts. While appreciating the critical work of the committee, it is my considered view that the proposal for death penalty in the Terrorism Prevention and Prohibition Act Amended Bill SB 969 be dispensed with. Our focus should remain on the certainty of punishment rather than its ultimate severity, and the bill may consider alternative sentencing such as life imprisonment without the possibility of parole for persons convicted of such offences. Mr. Chairman, distinguished ladies and gentlemen, the Federal Ministry of Justice advocates for a robust legal framework that prioritizes the certainty of apprehension and the speed of conviction over the ultimate severity of the sentence. We recommend that the bill focus on enhancing investigative powers and strengthening witness protection protocols to ensure that terrorists never return to the society. I thank you for giving me the platform, and I wish you very useful deliberation. Long live the Federal Republic of Nigeria. Thank you. Thank you, Honorable Attorney for the presentation. We're going to call on those who may have presentations regarding terrorism.
I will be very brief. I listened to the Attorney General and the NDA and the human rights. I think they are saying the same thing. Basically, you are opposed to death penalty. And you cite two reasons. One, international conventions. I'm not sure whether those are ratified by Nigeria or not. And some moratorium, some external positions on this issue. When each time you use the word international community. The second is about, you more talked about no evidence that death penalties have stopped people from committing murder. By the same logic, the absence of death penalty, there is no evidence that it has also discouraged would-be murderers. So this question is either here or there. Now, we in the Senate, in drafting this bill, takes into account the sentiment of the Nigerian people. For example, you are at liberty as lawyers to, in the open, defend a murderer, and you go home and sleep. I, as a senator, when somebody from my constituency is killed by a kidnapper or set of kidnappers, and they see the person walking freely, or he goes to court, and the court asks him to go and spend 5 years, 10 years in prison, meanwhile their loved ones have been killed. Our people do not understand that as justice. The law of society must reflect the values of the aggregate views of community, not of the learned minds, not of the senators. Today, I still stand. I have been harassed, not only me, every senator here, each time people from our communities across the country are kidnapped, and in the process, some are killed. Women have been raped, and after rape, they are killed. Children have been orphaned. So, for those who talk of human rights, whose right? Do the right of a widow, of a woman who has been widowed by the father, the husband has been killed, is it human right? The right of a widower whose wife was killed by kidnappers, does she have human right? Children who have been orphaned, who as a consequence may not be able to go to school because their parents have been killed in the course of being kidnapped or even after being kidnapped. The right of these children, they do not come within human rights. Is it the right of the criminal that matters, not the right of victims? For me, all of this fell in the realm of value system. You can hold the view, as a matter of value system, not law, that people who kill need not be paid. It shouldn't be an eye for an eye. That is a value judgment. And law is a function of sets of values of those who make laws. So my view, which is informed by the views of my constituents, and we have some senior lawyers, let's say, from a donut. You know how I have been blackmailed, harassed, intimidated, when kidnappers kill people from minor seminaries in Nigerianpolitics, when they kill the Reverend Father Atinka, when they murder farmers in various local governments in Edo North, and people are calling for their head. When they apprehended, you remember the report led to the burning of a police station because the policemen were trying to protect a man who has killed 7 persons and buried them in the compound of someone in Nigerianpolitics. The views of this community is that he who killed should face the wages, which is killing. And I speak as a man, because when we talk about congestion in prison because governors are refusing or hesitating to sign. I want to say to my credit, I use the word credit. Credit need not be like medicine in the real world. If something is positive, it's celebrated. But in medicine, if you test positive to HIV, or you test positive to any disease, it is a problem. So, for me, it is even not correct, or let me say it is arguable, the definition of international community. As we speak at the general staff, with due respect, America still executes people in some states. They are part of the international community. China is one of the world's most populous nations. As we speak, they carry out execution even of cases of corruption. As we speak, India, which is the world's largest democracy, they execute if you commit an offense that carries death penalty. So, who is the international community? Is it the minority in Europe? Because we should be looking at the totality of world population and ask ourselves, if you take together nations with death penalty, these are these nations without death penalty, which one represents more people? So I think we must be careful not to adopt minority Western views as tantamount to international community. I do not accept that. Lastly, sir, and like I said, even the US, the godfather of human rights, they execute electronic execution and they divide various ways and means of settling and they still execute it today. They are probably going to elongate the list. So I want to agree with the community people that we as senators making laws, we are looking at what our people want. Our laws should reflect the expectations, the feelings of those who employ us to make laws for them. Those laws must reflect their values. I saw here a very problematic submission by the NBA. Mr. Chairman, in the summary 2, replace mandatory death penalty with discretionary sentencing, including life imprisonment or death in aggravated cases. Parliament has to make every effort not to transfer powers of punishment to courts and leave the court to interpret laws made by Parliament which reflect the values of society. The role of the court is to interpret those laws, not their personal feelings. That is why when the judge talks about being a Christian, if you were a pagan, will you interpret the law differently? So we have to remove this thing outside the realm of our personal conviction to try and reflect what the ordinary man of the street feels until we move to that level. Sir, and this is the last point. When two people approached me when I signed the death penalty, one was a representative of the Pope, and the other was I think EU ambassador. I said, even in the laws of God, and I believe there are lawyers here who are also pastors, the Bible sanctions death. And even God, all forgiving, created hell. And that hell will be populated by those who committed heinous crimes. And in the Bible, no crime is worse than taking the life of the most precious creation by God Almighty. So even my religious values support death penalty. The same thing with Islam. We have Muslim senior advocate here and lawyers. The Holy Quran support death penalty. So in this room, you are either a Muslim or a Christian. In my traditional values, pagans tell us that it is forbidden to kill. And if you kill, unless you kill for pagan, whatever. But even in those days, if you kill, the entire community even before you are sentenced, they take law into their hand. So, sir, I thank you for your exemplary latitude to do what I shouldn't do at this stage, because I've been able to listen to them. But I wanted to share with you what informed this. So the sophistry between whether you kill as a terrorist or you kill as a kidnapper is academic. The end result is what matters. The only point we might consider, sir, is if in the act, in the course of kidnapping, you didn't kill your victim, there might be a case. If you did not. But if death results from the act of killing, of kidnapping, the distinction between terrorism, because even terrorists, when they are operating, it is not all of them that they kill. So he who kills should have no right to live. Those views I hold dear to my heart as a Christian, as a believer in God, that God's precious creation should not be wasted by evil-minded men. And if they do, Parliament should have the courage to make laws that will settle them to the Hades. In the words of Justice Achille, when he delivered the judgment on a woman, on a man who killed a woman, dismembered the body, and buried the parts in different places. He said people like this are only fit for the Hades. I subscribe to those values.
I want to tell you, this is a terrain, with all respect, that I am so well placed to know what obtains. If you, from the nature of terrorism activities, you cannot get them here all the time. They run to neighboring countries. I, as the chair or head of CAU, Central Authority Unit, where mutual legal assistance are usually sought, when you ask for the repatriation of certain, I won't say criminal suspects, the standard they use is theirs. If you do not conform to that standard, they will not. So they prefer to keep them there. In the case of America, that you have mentioned, it is not a state matter. It is a federal matter. If you ask for mutual legal assistance, it's not a state of Illinois or Maryland that will do it. It's from Washington. So the standard is by Washington, not any of the 50 states in America. And the position is clear. We have to be very wary of winning something and losing the battle. We have to be very, very practical. We need to fight it. That is one. Number two, you may honestly be swaying sentiment in favor of suspects. The way some of the judicial, I'm not a judge, but the way some of them think at times, and they are human beings, is along the line of, oh, I have a choice between leaving this man or convicting him. Oh, if I convict him, I'll be mandated to sentence him into death. They rather leave him. We have to be very practical. We are all involved. We are all concerned. We are all pained. But softly, softly. Thank you very much.
I'm Mr. Chairman, but I want to remind you that in Guantanamo Bay,